Technology, Media and Telecommunications Committee webinar. This is the first for this year. We left 2 weeks, the last 2 weeks, so that people could prepare and come back to, well, they could essentially prepare and come back, and now we are ready. So I thank you all. There are about 200 people so far registered for this event, and I was wondering why it was so small. Then I realized that everybody that registered for the event had either had to have paid a registration fee for this specific event or registered for the NBA-SLP in the last since January 1st this year. So this means that you people have everybody here has spent money to be able to attend this event. So I'm particularly grateful. This shows that you consider this important and you've taken your time. And indeed, before the session started, by the time I joined, we were ready for something people, and then in the next few minutes, it's going to be full. So I thank you all very much, and we still have more people registering. We've had a lot of calls, texts. Oh, please, I'm trying to register. It's not working. Something is happening. So I'm grateful. I'd like to do a bit of housekeeping before I continue. While I'm telling everybody thank you. As you all know, this is the NBA section on legal practice. Um, and then this webinar, the topic of the webinar, the section on legal practice is one of the sections of the NBA-SLP. There are others. There's a section on business law. There's a section on public interests and development law. Is it development and litigation forum? And there are a number of other ones. So as a member of, you can join either one or all of them. The MBA, there's no restriction, so there's no saying that you have to be a member of SLP and then not be a member of that. So if you're already a member of one section, you can join the other section. This section comprises of a number of committees, several committees. If you go to our website, you should see the list of committees. Once you register, you are free to join any of them, and then there's an icon so that you can join the WhatsApp group of those individual committees. From time to time, there are different positions, different opportunities, um, different positions available for people to join. So you are welcome to join. Many times they'll seek for volunteers, other times they'll seek for other things. But you're welcome to join and enjoy these sessions. As you know, most of our trainings are done every weekly on Thursday, and they are generally free for members and then paid for non-members. A small fee of 5,000 naira, small amount of money, less than $4. So again, so I welcome you all. One more point. This event is we are going to still do it next week, Thursday. There's also going to be another event on the 26th of this month. That event is a joint event between us and the SBL. That is free for everybody who wants to attend, whether you're a member of the SLP or not. So please do want to register. Check your emails for more information. Damilola Alabi is going to give us information about the CLA when the time is right. Again, on behalf of the chairman of the NBA-SLP, I welcome you all to this event. And I'm going to now close my mouth so that Damilola can usher in the people that you saw on the flyers who want to speak with you. Thank you very much. Damilola, please, you're on. Okay, so Mr. Wellington, well, you're up now, so you can introduce yourself and the speaker, and then we can go ahead. Thank you very much.
Thank you very much, Mr. Fernandez. It's your contribution to the success of this committee. We do not take it for granted. I would say good afternoon to everyone on the call. Good afternoon to the learned justices and judges here present. Good afternoon to the senior advocates here present. Good afternoon to every learned colleague, both senior and junior here present. My name is Terry Wellington. Terry is spelled T-E-R-I. I am a partner at the Wellington practice, and I will be your moderator for today. So I would begin by introducing the speaker for today. The speaker has a very rich portfolio. I had to summarize this portfolio into three succinct paragraphs. It was a very difficult job uh, summarizing it because, when your work speaks for you, it's very difficult to be brief. So our speaker for today is Isioma Idigbe. She is a partner at Punuka Attorneys and Solicitors, and she heads the Media, Entertainment, IP, and Technology practice at Punuka. She obtained a Bachelor of Law, LLB, from the University of Kent, Canterbury in 2014, and graduated from the Nigerian Law School in 2015. She has certificates in Entertainment Law and Blockchain Law from the Osgood Law School, University of York, Toronto, Canada. She has led a team in advising clients on major foreign and domestic investments into the creative industries in Africa, notably advising Afrexim Bank on its landmark $1 billion film facility. She has also been involved in major regulatory work in creative industries in Nigeria, notably acting as team lead on the landmark diagnostic study on collective management of copyright in Nigeria, commissioned by the French Development Agency and the Nigerian Copyright Commission.
Mr. Wellington, your audio is, I don't know if it's from my hand, but I'm struggling to hear you.
Okay, is it better now?
I think so.
Okay, I guess my mic was a bit far from. Okay, so where did you begin to struggle to hear me? At what point?
Maybe the last, maybe two sentences before I interjected.
Okay, so I've taken one paragraph, so I will begin from the second paragraph. So she has led a team in advising clients on major foreign and domestic investments into the creative industries in Africa, notably advising Afrexim Bank on its landmark $1 billion film facility. She has also been involved in major regulatory work regarding creative industries in Nigeria, notably acting as team lead on the landmark diagnostic study on collective management of copyright in Nigeria, commissioned by the French Development Agency and the Nigerian Copyright Commission, and in the year 2020 as a member of the technical working group set up by the Federal Ministry of Budget and National Planning to develop the medium to long-term national plans for Nigeria's culture, creative, hospitality, and tourism. More recently, she worked with the Federal Ministry of Arts, Culture and Tourism and the Creative Economy, FMACTCE, and Google Nigeria on assessing the impact of artificial intelligence on Nigeria's creative industries, amongst others. Aside her law practice, Isioma is also the founder and the director at Verif Content, a due diligence company that carries out diligence checks on intellectual property in Nigeria. And she's also a founding trustee and the secretary of two major associations in the music industry in Nigeria. Those associations are the Music Publishers Association of Nigeria, MPAN, and the Record Label Proprietors Initiative, RELPI, as well as the co-chair of African Regional Group of the International Confederation of Music Publishers. She acts as the project director at the African International Film Festival, AFRIF, and she was recently appointed as an advisory board member of the African Film Finance Forum. She is ranked as a leading IP practitioner by IP Stars, as well as a leading media lawyer by Media Law International, MLI. She is a recipient of the Rising Star Award at the 2018 Law Digest Awards, and in the year 2020, she was listed as a Rising Woman in Africa by CNBC Africa in recognition of her legal work in the Nigerian media and entertainment industry. So in three very short, maybe not too short paragraphs, we've been able to introduce our speaker very briefly. Our portfolio spans way more than this, but we have to summarize it as much as possible. So you're very much welcome, Isioma Idigbe. You have the floor. So before you proceed, we will be having a presentation from our speaker and also a question and answer session. So the presentation would come first, then the question and answer would follow the presentation. Thank you very much, everyone.
Thank you so much, Mr. Wellington, for the introduction, and thank you so much to the NBA-SLP for inviting me to speak here today. I always appreciate an opportunity to share the knowledge that I have and also to contribute to the Nigerian Bar Association in this way. Unfortunately, I'm not very good with getting more involved, so it is the little way that I can get involved. And Happy New Year to everyone who has taken time out to join today's session, and I hope we all had a good holiday. So I'll just quickly get into my presentation because I know that we are wanting of time. Okay, so today we'll be talking about drafting of media and entertainment agreements. And I think before we start talking about that, it would be good for those who are not familiar with media and entertainment to really talk about what is entertainment law and just kind of give you, first of all, an introduction into kind of what entertainment law is before we start going into how contracts kind of work in media and entertainment. So entertainment law is an area of law practice that is really focused on the entertainment industry, which includes areas of film, television, music, theater, arts, publishing, sports to an extent, gaming, printed media, digital media. So when we say printed media, like actual physical newspapers, and when we say digital media, you're looking at like blogs and even digital versions of newspapers, commercial gambling, mention sports again. So it's quite broad. And legal work in this area could cover a plethora of things from employment law, finance law, intellectual property, and corporate law. And so there's a broad range of opportunities for people working within the sector, right? I wanted to just talk about how intellectual property law is so critical in entertainment law, particularly copyright law. And I always say that for the weapons of war that an entertainment lawyer needs is a strong understanding of corporate commercial law and a very strong understanding of intellectual property law. Because a lot of the time, what you're doing as a media and entertainment lawyer is really creating the contractual relationships whereby these intellectual properties are being essentially like commercialized, monetized, or traded, right? So in Nigeria and across Africa, the entertainment industry has evolved into a global export, especially things like music, film. Sorry, I'm being told that you can't see me very well. So I need to adjust my this way. I should face this way. Okay. Is this better? Oh, I should face the screen this way. Okay, is this better? Okay. Okay, yeah, I can see now. Sorry about that. So, and the entertainment industry, we're very popular, especially in Nigeria, for our music, our film, and our digital content. In fact, yesterday, I don't know how many of you were watching I Show Speed live streaming on YouTube here in Lagos. They actually drove past our office, and I went out on my balcony and I was shouting, "Speed!" And he was able to reach 50 million subscribers during his time in Nigeria, which was a landmark for a Black YouTuber, to tell you how far our content creation has gone. And if you're watching his stream, he did collaborations within that stream with other popular Nigerian TikTok TikTok content creators and the rest. And of course, our arts and our sports, we were just coming off of AFCON and we saw the controversy. Again, we medaled, wasn't the medal we got, but bronze is still not bad. And of course, our fashion are all international commodities. So when you see these things, you have to understand that this is actually money and business for lawyers in all these things that are growing and are receiving such global recognition. And so entertainment law really, like I said before, is an intersection of intellectual property, ownership and exploitation. Contract law, which is what we'll delve in here, multi-party, multi-jurisdictional, becomes a huge, this issue of multi-jurisdictional is major, especially when you're looking at things like online media, like social media. How does that work? The internet and how that changes everything, AI and the rest. Corporate law, structuring deals and entities, labor law, regular regulatory laws and tax laws, so some of the key regulators for us will be NFVCB, which is the Censors Board, the NCC, which is the Copyright Commission, also the Communications Commission, so the two NCCs, ARCON, which regulates advertising, withholding tax royalties, etc. Right, so this is where you're playing in, and these are the things that your contracts are dealing with. So the legal frameworks that you concern, I have to say that this is not extensive, but some of the key ones that I could really remember and bring out: Copyright Act, the Trademark Act, the Patents and Design Acts, the National Film and Video Censors Board Act, ARCON, the Cybercrime Act, the NIPC, the new tax law, major changes for the creative industry under the new tax law. Several case laws. This is not a sector that is heavily litigated, so we are still building our case law, but we're getting more and more cases each year, which is great. We still have a long way to go, and I'm hopeful that we have people from the judiciary joining us here today, because I think the entertainment industry needs to do a lot more work in getting the judiciary to know more about what they do, to be able to properly adjudicate their matters, because I believe the intention is there, especially at the Federal High Court, which is where you tend to be, and other subsidiary legislations. And so your key regulatory bodies are the Ministry of Arts, Culture, Tourism, and the Creative Economy, FMAC, TCE, NCC, and we've talked about this, ARCON and the rest. These are like regulatory bodies, trade associations, and professional bodies that you would engage with as an entertainment lawyer, and these things are relevant when it comes, into your contracts. So contracts and entertainment law. In entertainment law, contracts usually are designed to define ownership, payment, things like creative control and distribution, right? And there are common forms of contracts that you would tend to repeatedly create or draft, rather, as an entertainment lawyer. So you have recording contracts, which are relevant to the music industry, publishing contracts, which are relevant to the music industry, and also the literary, like publishing industry. When we're talking publishing, we're talking about books and things of that nature, endorsement agreements, a lot of advertising. Advertising is almost like in tandem with media, right? If you look at the history of television and why did television become a thing? Television essentially exists to sell goods and services. Television cannot work unless there's sufficient advertising to support it. And that's why you see, like in a country like Nigeria, our television market has not grown, or is not properly developed, because that relationship is not well established. And I know that the Nigerian Broadcasting Commission is doing another rounds of review on the broadcasting code. I encourage lawyers to participate. It's closing at the end of this month, because there are certain key changes that need to go into our broadcasting code to really revive the television sector. The television sector is one of the largest parts of entertainment and media business anywhere in the world, and it's very sad that it's underperforming in Nigeria. And then licensing agreements. These are some of the common forms of agreements that you would face, and there are key principles that should guide how, as a lawyer, you create these contracts. You want to make sure that the issue of consent is explicit. Remember, I talked about the fact, if we go back, right? Let's go back a couple slides. The intersections, and talk about intellectual property, the intersection of ownership and exploitation. So it's very key when you're looking at the key principles in contracting of media and entertainment contracts, because the issue of consent is sacrosanct. When you're doing these contracts, you're in most times you're managing a commercial transaction where the transaction really is around some intellectual property that somebody is giving and somebody else is taking, usually for some consideration. So the consent language in there needs to be explicitly clear, especially in a country like Nigeria, for example, where it is clearly stated in our laws that assignment of rights must be written and explicit, right? So those consent languages must be clear. And there has to be clarity on consideration, which in this case can be consideration other than cash. So let me give you a practical example. I'm doing a film production, but I need so and so people to offer services, and I don't necessarily have cash, or I don't have the complete cash. So sometimes those services can be exchanged as consideration other than cash. And if those services produce some kind of intellectual property which you must acquire to be able to sort of exploit the final product, then you have to also make sure that that consent and that conveyance is clear as regards that consideration and the accompanying consent language. And there has to be absolute clarity of terms, especially in a market like Nigeria, where the market is not heavily sophisticated. It's a relatively new area, especially when you're looking at like adjudication. So you need to have clarity of terms should there be a situation whereby that contract has to now be disputed. And of course, your dispute resolution and governing law language has to be clear. Again, this becomes increasingly more complicated when you're looking at things that are fluid, like social media or online media. How does that work in terms of jurisdiction, dispute resolution, and governing law, the rights, the obligations of parties, termination clause, etc., etc. But I always like to lay down these key principles because, in my experience, when you use these key principles in how you create, review, your contracts, you are likely to create high quality contracts that protect whoever your client is at that given time, or at least enable whatever that transaction is at that time. So contracts are the foundation of entertainment business. In more developed markets, right, if you even look at like established entertainment like companies, you will find that the business development department and the legal departments are joined, because contracts are actually the foundation of entertainment business. And unfortunately, many creatives in Nigeria are still operating informally, although this is changing. I've been doing this for 11 years, I think this year, 11 or 12 years this year, and it has changed dramatically from when I first started. And this leads to disputes and legal battles. So a well-drafted contract will define ownership, creative control, remuneration, duration, and distribution rights, and will set out the rights and obligations of collaborators. The entertainment lawyer ensures that the contract is clear, fair, and enforceable, providing commercial foresight and protecting clients from exploitation. So what are the common mistakes that we see is verbal agreements. We are family, we don't need papers. Ambiguous ownership clauses, missing territory definitions, no recruitment waterfall, no language around even recruitment in a situation whereby the consideration is forecast into the future, right? And then perpetual terms. These are some of the things that we see that make contracts fail. Perpetual terms, or even no terms at all, no clarity on as to how long this agreement or contract lasts for. So for a contract to be valid, we already know this. There must be offer, acceptance, consideration, and an intention to create a legal relationship. So we've already talked about some of the contracts. We'll go a little bit more into them. Financing agreements, which you see across different sectors. But financing is also a major consideration within the creative industry, and they're in entertainment law, because these things that they produce require money to produce them, right? You have talent contracts, distribution agreements, co-production agreements, split sheet, which is very relevant in film. And then even when you enter into agreements with insurers, one of the more difficult agreements that I negotiate are when I'm negotiating agreements with insurance companies in Nigeria, because you have to make sure that the clients, and this is usually very relevant in film, so that's why we have the example here of a production company. They are protecting them against risks arising from like copyright infringement, which for an insurer, they're like, this is an intangible thing, right? They don't understand defamation, invasion of privacy, concept that under like regular hard asset things, the insurance company can understand, but some of all these like softer, intangible issues to be considered a bit peculiar for insurance companies in Nigeria, but they're getting better as they do more and more of these things. So like I said before, you have to be dealing with ownership and exploitation, right? I think I've even preempted some of these things that are going on in the slide, but for it to land, but I will go into them. Timeline for completion is also another thing that, and that's why I talked about the term. For example, if your client is engaging someone to provide a particular service, you need to give them timelines for those tasks or milestones for the progress of the work from start to finish. Because anyone who works with creatives know that creatives like to have no timeline. But on the business side of things, that doesn't work. So having clear timelines for completion and tying those things to material breaches within contracts are significant. Budgeting and how is budgeting and budget overrun handled, financing, equity and recruitment, we've talked about that. Now, credits and acknowledgement. I really want to spend time on this because this is very peculiar. Now, credits in the creative industry is almost as important, or if almost equal to financial compensation, because your credit is your portfolio that you have done this work, and that sort of allows you to continue to get more work or more exposure, whatever it is growth. So a situation where someone has created something and they're not giving the appropriate credit can actually amount to a dispute. And that dispute can even escalate into an intellectual property law dispute, especially in a situation whereby this person who has created this work was not necessarily compensated in cash, either 100% or completely. And some of that compensation was maybe, let's say, meant to be some future share of revenue recouped from the finished product. And if you don't credit them, it could mean that they miss out on that. And they could come back under the Copyright Act that does not allow for one to assign their moral rights, to actually retrench the rights they have given you, which in that situation will leave you as the person who acquired or who thought they acquired those rights stranded from even exercising the use of the final product. And the film and music industries are classic places where these issues happen, right? So you as a lawyer have to make sure that the issues of credit and acknowledgement are clear. Even when you look at a situation whereby, let's say, part of what you're using something, or you're using something that, and maybe the argument for how you're using it is that it's fair use. When there's no acknowledgement of where it is gotten from, it could actually vitiate the you falling under the cover of fair use to be as a to say that you have not infringed. So these are things that you have to look out for when you're actually dealing with contracts within this space. So some sample clauses in contracts, of course, we know the introduction clause, which identifies the parties involved and the basic information about the agreement. So this is, I don't know, a financing agreement. This is a production agreement. This is an agreement with the director. This is an agreement with the production designer. This is it clearly defines what that is. And I think I always say that in the creative industry, definition clauses are like lifesavers, because there might be certain clauses or words that are used that are sector specific that you need to define what it is, in case someone who is not familiar with the sector, particularly like a judge where the contract is challenged, can refer to those definition sections to understand sort of what the language is that is in the contract or what was intended. The scope of work that describes the specific tasks and duties or services, term and termination clause that defines the duration. Now, this issue of duration, I want to bring in another example as to the intersection between this issue of intellectual property and corporate commercial law. Now, especially in a situation where this contract is granting one part of a series of rights that an individual or a body corporate requires to create a product that would deal with that they would ultimately exploit, right? You want to make sure that you have, as the entity that is acquiring all these little rights to create a bundle of rights, that you have acquired those rights for the duration that you need to exploit it in the future. So the issue of term is so critical because of the intellectual property rights issues. And I know that people are going to ask me questions, so I will give more examples during the Q&A for want of time. But you need to think about this. And then also what happens during termination, especially when you're looking at how intellectual property rights work within entertainment and media contracts, is also something you need to think very deeply on and be very careful in drafting. An example would be, let me use the example of a co-production agreement. And this example I'm giving are real life things that I've seen play out in the course of work that I've done. So, this is a co-production agreement between two producers, right? They're trying to produce, let's say, a TV series. And you have to draft the termination clause. Now, the contributions of these producers are, different things. One producer, let's say, has written the script, whilst the other producer is really doing like all the production work to, package the project for financing and do all those other tasks. So what happens if, for example, the producer who brought in the intellectual property, which is the script, decides that they want to terminate this production? What happens to the production in a situation like that? And what happens to the other producer who has been investing time, right? So you have to create, so things, for example, a rescission clause, which will say that you can leave, but you cannot rescind the rights that you've granted, right? And that in exchange for that, you would then be included into the waterfall being the compensation structure of how everyone is paid according to their equity in the project. Like, you have to think about those kinds of things, because if you don't draft your contract right, you're going to put your clients in a situation where they will be stuck. And for each day that they cannot resolve the issue, the project sinks more and more into failure and debt. Payment clauses, confidentiality clauses, very critical, especially, again, tied to intellectual property infringements potentially. So these confidentiality clauses have to be really, really tight, and on whom the onus of confidentiality is. Indemnification clauses. All these things are all tied to potential infringement. So, for example, let's say I'm a distributor, and I acquire a film from a producer. I definitely want language in there that I am indemnified from any third-party intellectual property claims that arise from the production, because I didn't produce it. Why should I be liable? Now, it's not this, for example, under Nigerian law, an indemnity clause really is not a 100% shield, right? Because the law still says anyone who has exploited is liable. But what it does is that it allows you to cascade the risk back down to the producer, right? Or whoever it is that gave you that right that you acquired. So indemnity clauses are linked to potentially protecting your clients from, the issues of infringement. And of course, intellectual property clauses, which clearly address ownership, acquisition of same, granting of same. Now we have to be thinking about things like AI. So, for example, even very recently, and it was quite funny, I had a contract for an actress, and the other law firm had recently been in a training that I gave, where I talked extensively about AI. And it was interesting because when they sent a good contract, it included the producer in that film wanting to acquire the rights to do an AI replication of our client. Because for the producer, it is beneficial, because you don't have to pay again or be trying to work out schedules if you need to, let's say, create reshoots or something. And of course, representing the actor in this case, we rescinded that and said, no, you cannot replicate her performance, her image, in AI, right? Because that would be a loss of income for her. So, just those interesting things that are now beginning to come up with AI. Governing law, which laws would govern the interpretation and enforcement of the contract, as well as the jurisdiction where any dispute will resolve. This is extremely complex these days, especially when you're dealing with like cross-border things. So I'll give you an example. A UK producer is coming to come and shoot something in Nigeria using Nigerian cast and crew. You start asking yourself, what's going to be the governing law and where would disputes be resolved? These are real life issues that we are dealing with. And it's usually quite challenging. There are certain things you have to think about. Is one is, depending on who you're representing, where is the easiest place for them to adjudicate a dispute? Where would they likely get a good decision? And unfortunately, some of the things that we now have to think about sometimes is what jurisdiction would have enough experience within their judicial system to be able to address any disputes that arise from this sector. Many a time, we're beginning to move towards ADR, because in ADR, of course, you can pick experts from the space that can actually adjudicate, as a forum, can adjudicate and resolve these disputes. So again, I think there needs to be so much more work done from the creative industries, the creative and cultural industries, in terms of training the judiciary to be more up to date with how their transactions work, so that we can get more relief from the judicial system. And also the speed of the courts as well makes it quite challenging to use the courts as a forum. And I'll give you a very good example. This is a case that is documented, so I can talk about it. Okafor's Law. Now, in Okafor's Law, the judge at the first court of first instance actually gave it an expedited hearing status, and that was quite brilliant, because they understood that we're talking about a film that the premiere had been stopped by a Mareva injunction. So to tell you that the issue was live and needed to be resolved. But unfortunately, the decision was not in favor of the of our clients in that case, and now we are appealing. But the point is that, being that the decision did not go in our client's favor at that time, ultimately the film came out in cinemas, has done its run, and we're still going to the Court of Appeal. So it doesn't matter whether at the Court of Appeal or the Supreme Court, if the decision is overturned and is put in our client's favor, our client can never really be put back into, there can never really be a remedy for our client, right? So that just tells you the peculiar nature sometimes of how the issues that come up in creative industry can be, because the judicial system must take course and take its process, but in that process, financial compensation, if they even get that at the end, does not suffice. And that's why you see in certain markets, you have like fast track, expedited courts that are specific for this area, because there's an understanding about the nature of these disputes, and if they are not dealt with timely, even if financial remedy is not sufficient in that case. Force majeure clauses have to be dealt with very carefully. I remember a situation during COVID. We had a clause in there that said, obviously the producer, again in this case, sorry, it takes some more time. Again, in this case, we were representing an actor, and the producer obviously had wanted to put force majeure clauses there, basically in case there was an outbreak on the set. But we had put a counter language that if that outbreak was a result of their breach of the COVID-19 protocol, then the force majeure clause would not apply. And unfortunately, that became a reality on that production. But luckily, we were able to get compensation for our client, because there was also a language within the contract that said that if our client had to stay for additional terms on that production, then they will be paid a particular amount of money every day. And by the end of that production, because I think she needed to be locked down for 2 weeks before they even started shooting, she ended up walking away with double the amount of money, because they had to pay her for those 2 weeks that she was locked down. If we had not put in those languages in the review, our clients will not have also lost income from not being able to be on another set for those 2 weeks. They would have also not even been able to be compensated for being exposed really during that period. So you can see how I also had another situation. There's something called a pay or play clause. This is usually very relevant in film, so that's why we didn't put it here, because it's a very film specific language. And it's basically a clause that says that as long as you've locked me down to perform during this period, whether or not you go ahead with your production, I will be paid. The thinking behind that is that when you lock someone down for a period of time, you exclude them from being able to be on another production and therefore generate income. So whether or not you have an issue in your production that perturbs you from stopping, they will be paid. And our client was the only one that had that clause in their agreement, and they were the only ones that were paid for 6 months. This was a TV production, for 6 months after the show no longer aired. So again, this is also examples of how the right kind of language in your clauses can protect your clients. The absence of those clauses can leave your clients without options when things happen. So the assignment clauses, severability, these are now boilerplate: severability clause, notice clause. This issue of notices can, notices are things you really need to take seriously, because information flow is important, and having a framework within your contract of how they communicate with themselves, the parties, multiple parties, is important, because even if there's a dispute that arises where information is not officially communicated through the whatever forums that have been agreed on in the notice clause, then it makes it easier to sort of sift through the issues, or even identify that there's an issue because of how that is being communicated as stated within the contract. The amendment clauses are standard clauses outlining the process for making changes or amendments to the contract. And then the entire agreement clause, which confirms that the contract contains the entire understanding between the parties. The level of informality within the entertainment industry is actually so important that you have this entire agreement clause, because a lot of times people take their soft conversations and believe that that's part of what they've agreed between parties. So this is just some examples of just, these are like standard clauses. I'm sure we all know these boilerplate clauses. And all of that. I've talked extensively about dispute resolutions, but just to say that the entertainment industry is prone to disputes involving contracts, IP rights, royalties, image rights, endorsement, etc. Now, I wanted to just spend a minute to talk about globalization and cross-border licensing. So globalization has transformed the entertainment industry by breaking down geographical barriers and enabling creative works to reach audiences worldwide. But this expansion has made cross-border licensing a crucial aspect of modern entertainment law. And through cross-border licensing, creators, production companies, distributors can commercialize intellectual property and across multiple jurisdictions while maintaining control over the usage rights and revenue streams. But this introduces complex legal challenges such as territory rights management, determining which markets are covered under a license, royalty collection and enforcement, ensuring compliance and fair compensation across different legal systems, cultural and regulatory differences, adapting content and contracts to fit local laws, tax and currency considerations. Yeah, I talked about how this new tax law has created a whole plethora of complexities. And I think any good entertainment lawyer really needs to have a good understanding of tax law in today's world, especially in sectors like music that are so cross-border, and you have creatives and companies that are generating revenue from all these markets. There needs to be so much more focus now on tax efficiency and managing the financial obligations that are arising in these multiple jurisdictions. And so as entertainment lawyers, we play a key role in drafting comprehensive cross-border agreements that ensure IP protection and align with international treaties like the Berne Convention, TRIPS, and the rest. And so there needs to be heightened legal sophistication around safeguarding these creative and commercial interests. So in conclusion, every business transaction in entertainment is founded on a contract, yet many creatives in Nigeria continue to operate informally, signing agreements legal advice or documentation. And an entertainment lawyer should ensure that every clause is explicit, fair, and enforceable. A well-drafted contract reflects not only legal competence, but also commercial foresight. You can see for some of the examples I gave is your foresight is preempting a future issue for your clients, depending on which side of the fence you are. And so it anticipates future uses of your work or whatever the commercialization that is happening within that contract is. And so, at its core, right, entertainment law brings together the key legal issues that sustain creative media industries. And at its core, intellectual property protection, contract and commercial law, corporate structuring, advertising, media and regulation. These are like the key things that are bundled within it. And in the digital era, you have to be looking at things like data protection. I just gave the example about AI, for example. You have to really think more about dispute resolution because of the fact that this is essentially a new commercial interest in Nigeria. And so that you have there's still a dearth of knowledge, a dearth of precedent when you're looking at dispute resolution. But ultimately, entertainment lawyers and good contracting is the backbone of Nigeria's creative economy. And so lawyers must combine legal expertise with also commercial creativity. And the future of entertainment law and good contracting lies in innovation, collaboration, and to an extent proactive regulation, because we do have regulatory gaps that are making contracting within the space a bit more protracted than it needs to be. So I'll just leave with that. Thank you very much. And I think we can take some questions. Thank you.
Thank you very much, Isioma. It was a very packed presentation, and I learned a whole lot. I'm very sure everyone on the call also learned a whole lot from the presentation. I took as many notes as possible, and I came up with some questions, which I believe would further the understanding of and knowledge of the participants, concerning intellectual property and the areas of law you have spoken about. So I will go into the questions immediately. And the first is, we have seen from your profile, and it is very impressive, and it is one that every young lawyer would want to attain. So now, can you tell us if there are any pitfalls in drafting of media and entertainment agreements that can lead to legal liability for a lawyer? If there are any pitfalls in the drafting of media and entertainment agreements that can lead to legal liability for a lawyer and not the lawyer's client. Instances where the lawyer has to, answer for a properly or badly drafted agreement. Are there instances? Is it a possibility? Thank you very much.
My answer to that would be, it would be a function of you failing at your duties to properly advise your client. And an ill-drafted contract that does not properly protect your client or address their interests within that transaction would expose you, as it would in any other sector, to potential liability. But one of the things that I find that people need to be, number one, I think what I found is that a lot of lawyers think that because we're talking about media and entertainment, then it's like casual, like it's not serious. And I find that a lot of lawyers straight out of law school. So in fact, I've been watching online, a lot of young lawyers are protesting against this requirement for pupillage. And I laugh because in other developed countries, I have a cousin that is a lawyer. I have multiple cousins that are lawyers in the UK. And I remember the day she told me she was finally a lawyer. I thought it was hilarious because this was like many, many years after she had gotten her LLB. But that's because the process in the UK before you even come out and say, I am now a solicitor, I'm now a barrister, is after law school, it's probably another three years of going, after doing your LLBs, another 3 years of going to law school, pupillage, and the rest. And what I find a lot is a lot of young lawyers who are naturally, young people gravitate towards media and entertainment, coming into the space and not having experience with how the transactions work, not having the guidance of someone who has that experience and advising clients, and you see those mistakes show up in ill-drafted contracts a lot. So my advice to lawyers is, if you get a client that is from the media and entertainment industry and you're not very familiar, do your research on the transaction dynamics and speak with anyone you know that is experienced, or sometimes just actually try to get as much information about the transaction dynamic from your client, right? And for young lawyers, try and get placements. If this is the sector you want to work in, then try for your first years of work to work somewhere that is doing real and serious entertainment law, to learn the rudiments. I always say that my superpower is the fact that I know these industries. I know their problems. I've been on film production sets. I've been on TV production sets. I've been on advertising production sets, right? I've been in music studios. I've been in garment manufacturing factories. I've sat down and been in projects that have allowed me to talk in depth with creatives within these spaces, or have allowed me to work closely with businesses within these spaces. And so I understand the commercial issues. And when I'm contracting for my clients, I am trying to preempt those issues in how the contract is drafted. That's the only way you can protect yourself as a lawyer. And sometimes when I have a client that is trying to make me do something that is not necessarily in their interest, then I make you sign an indemnity form and you indemnify me that you are acting outside of my advice. So another thing you're exposed to, especially when you're working on the side of creatives, is that they can be quite emotional. And also because they are existing in a very, very tough market and terrain, there is a hunger to just keep moving forward, regardless of whatever you're sacrificing along the way. So you have to be careful as a lawyer that you're not just doing what you are being told to do, but you are doing what you are supposed to do. And those are not the same things. So that's just the experience I've had. And that's where I think you actually have a lot of exposure as a lawyer, and what I think that you can do to manage those liabilities. Because there's something that my senior partner, Chief Tony Idigbe, always says: every client is a potential enemy. And that applies very much in this sector and in any other sector.
Thank you very much, Isioma. Your response to that question is like a mini class in itself. And I believe a lot of lawyers, especially the young ones, aspiring to follow in your footsteps and to do entertainment law generally, have taken as much as possible insight. And I was particularly pleased with the aspect of indemnification. You want me to, act outside the scope of my ordinary authority, then sign that you would be liable for whatever comes out of it. So thank you very much, Isioma. So to the next question, what has been your most daunting task in intellectual property? Since you've become an IP expert, what has been your most difficult brief?
I think I actually have, I think the answer to that is 2 briefs that I'm currently dealing with. So unfortunately, I can't really speak about them. But when they do come out, you would see why they are some of my most difficult briefs. But before these ones, I would have to say that the Okafor's Law copyright case was very difficult. It wasn't difficult in terms of like the case was clear and the precedent to be set, which is that proximity can be a ground to establish infringement, was very exciting. What made it challenging was having a client that had financial constraints, fighting a media war against a hugely popular personality and not being able to control those narratives, and that influencing what was going on within the court. And this was when I was I think maybe I was like 2 or 3 years post call doing this case, so it was still very fresh. Like, I was really I still think I'm a baby lawyer, but I was really like an infant lawyer, to be dealing with all of these dynamics, and also dealing with the disappointment when the decision did not go in our favor. I remember I was in Milan for a conference, and I was on the wall and I slid down, because in my view, we had done a fantastic job with that brief. We were on the right side of the law as far as we were concerned. And it was very disappointing, but it was good, because that was my first taste of the reality of how litigation works, and the reality that we really need to do so much more work in making sure that the judiciary is really familiar with how the transactions did work. Because whilst we did all that paperwork, at the end of the day, if the judge is not familiar with what happens in pre-production and production, and you know what I mean, like, there's only so much that they can do. And I think that's part of what propelled me into doing so much more work in terms of policy, in terms of capacity building, and things like that, because it was really that case really shook me. And I remember again, I remember my senior partner, my managing partner, telling me that I'm too emotionally involved in my matters. So I would say that has been my toughest one, and actually the toughest ones are ongoing. But that till now, that was the toughest case I've had to deal with, and case matters. I mean, of course, the Afrexim Bank job was a lot of work. Developing film financing framework, not just for Nigeria, for the entirety of Africa. And in the middle of this, I was pregnant with my first child. I just had my first child. So that was absolute chaos. So there've been a lot, but I think maybe these ones are like the real highlights for me.
Thank you very much, Isioma. So we move to the third question. If you did not venture into intellectual property law, what area of law would you have specialized in?
Actually, I wouldn't have been a lawyer at all. If anybody has ever listened to any of my interviews, I think I've said this so many times, that the only reason why I'm a lawyer is because of media and entertainment. And actually, IP law sort of came after. I really did not want to be a lawyer because of the fact that I come from a notable legal family. I wanted to earn my own, I guess, reputation. I had this feeling that I felt if I was a lawyer, there would be so much pressure. Nobody would ever believe I earned anything for myself. So I had no interest in really becoming a lawyer. In fact, I spent so many years running away from it. But there were a few I remember a conversation I had with my mom when I was actually trying to apply to university to study political science. And she asked me, okay, so do you want to be a professor? And I said, no, I don't want to be a professor. So she said, then why not just do law? You don't have to practice, but at least law will just give you like a good foundation to do anything. I know people don't know that when I was in school, I started a food business that I was running in university. And my plan was actually to continue that food business when I came back to Nigeria. It just so happens that my boyfriend at the time and my husband now was a photographer and a filmmaker. And when I came back to do law school in Nigeria, of course, you hang out, with his friends, and they were all creatives. And all the issues they were talking about were, because I was obviously a lawyer by training, they sounded like legal issues to me. And clearly, if I'm interested in food, I've always had an interest for the arts and things like that. And I was like, these are legal issues. And I would Google and I would see, wow, like this. That was how I discovered that there was something like entertainment law. And I was like, oh, wow. And I would go back to Punuka and ask lawyers, this is what I'm talking about, being trained. Oh, there's this situation, and I saw in America, this is how they would do it. Like, what would be the Nigerian alternative? And they would tell me. So when I go back to hang out with these people again, I'll say, I think you should do this, that, 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 that. Before I finished law school, people were already calling me. I had like 10 clients before I was done with law school. So honestly, the only reason why I'm a lawyer is because of media and entertainment. And I'll bring those clients to Punuka and I'll say, oh, obviously I can't represent them, but here they have these issues. By the time I was done with law school, I already had an entire clientele base of clients. And then I went back to school to study entertainment law because I realized I didn't want to just do it. I wanted to be excellent. I wanted to be the best. I wanted to bring high quality services to that sector that was clearly underserved. And that was how I started.
Thank you very much, Isioma. We appreciate the response. So I would move to the fourth question. And I picked this question from your presentation. Yeah, you said a strong weapon needed by an entertainment lawyer is knowledge of copyright law. Then what area of law will you say is the next most critical area for a successful entertainment law portfolio, aside from copyright law?
I think general corporate commercial law, you need to be a strong corporate commercial lawyer. You should be able to, especially if we're dealing on the issue of contracts, an entertainment lawyer in principle, a good entertainment lawyer should be able to handle any other commercial transaction in any other sector, maybe with guidance of someone who is familiar with the sector because of some sector specificity. The skills are completely transferable. So everybody knows me as an entertainment lawyer, but actually, look, I do a lot more than entertainment law. I do a lot, a plethora of corporate commercial transactions within the firm. But I can tell you that I cut my teeth in entertainment law, even down to how films are financed and the rest. It's completely not different from other sectors. There are just some specific sector specificities because of the intangible product that is involved, but everything else is on all fours with other stuff. So I would say having very strong corporate commercial knowledge, and also having, again, because I was groomed within an established law firm structure, and everybody knows that Punuka is really, really good at litigation. So when I draft contracts, I actually think about it from the point of a dispute, because I'm around litigation lawyers all the time. And when I first started, I used to go to court a lot. So because I have the end worst case scenario in mind, I'm trying to draft a contract that can stand up if we end up in court. So I think a good litigation lawyer with a strong corporate commercial knowledge is literally a deadly weapon when you look at entertainment law.
Thank you very, very much, Isioma. You caught me in my tracks. My next question was, I wanted to ask you the place of criminal law and litigation generally in entertainment law. Because I'm pretty much aware that our artists, our entertainment guys get into a lot of unnecessary trouble, So, but you answered that question already,
No, but I even want to
said,
go further and say that
okay.
we need strong litigators in the entertainment law space. There's so much the sector is becoming more dynamic, is growing year by year, right? There's even a government focus now to try and grow them. I hope that they trickle down on their policies. And so we're going to see more disputes. And even now, I can tell you now that in my practice, before we were very heavily contractual. We're now edging more towards litigation. So this litigation I've been running away from, I'm running into it now. So there's a huge space for strong litigation lawyers. But again, a strong litigation lawyer for entertainment requires the same fundamentals. They require a strong knowledge of intellectual property law, particularly when we're talking about entertainment copyright law, and a strong understanding of the commercial transaction. And then they can use their litigation experience to translate in how they're representing clients in cases in court.
Thank you very much. Thank you very much, Isioma. So I'll be moving to the questions in the chat box. Some questions have been dropped and I've identified some of them, which I feel, and there has been a very persistent one. It has been dropped about 4 times. I figure it was dropped by Morufu Ajibade. And the question is, in a cross-border contract between a Nigerian and a Tanzanian company, with the Nigerian being with the Nigerian being a country representative, which law should govern the contract? That's a question from Morufu Ajibade.
So this is a tough contract, but I don't know I don't know. I would need more details, such as like who is the dominant party, for example, within the transaction. And I'm just saying how I would think about transactions, right? Like, who is the dominant party? Who is likely to be the person to breach the contract or not? And where is such a person? So is it the Tanzanian? Is it the Nigerian? And also, unfortunately, one of the things with Nigeria is you have to know that there's a lot of hostility against Nigerians pretty much everywhere in the world. So as much as possible, if you are representing Nigeria, which I would assume, you want to try to be in as friendly of a jurisdiction as possible, right? So which means you want to be in Nigeria as much as possible. One way sometimes, if you cannot be in Nigeria, then maybe pick like the UK or something. And if you don't want the cost of going there, you can pick some kind of like ADR option that can be done virtually. You understand what I mean? So that's, I mean, I've been in these situations before, but those things will determine it. Who is the dominant party in the transaction, who is likely to breach. You understand what I mean? And if I'm representing the Nigerian, I would want to be in a forum that would be at least at the worst neutral, at the best favorable. So those are some of the things. And then there's always this issue of conflict of laws, because even if you go through, let's say, arbitration, and somebody wants to challenge the arbitral order, where in my view, I tend to sometimes just leave that open. You go to your own country and challenge the order, you know what I mean? And they will all meet ourselves somewhere. It also depends on the size. Like, this is not a question I can answer very easily, because it's actually always a very complex thing to decide what forum, which law, and whatnot. But a lot of times, if the UK is not involved, because it's a common law country, I would usually like maybe say the UK, maybe say arbitration, make it virtual. If they have a medium MSME scheme within the arbitral forum I'm using, then use that. Because you also have to look at the issue of cost. Again, what is even the transaction size? Is it what arbitration? Like, I also Maruf, I can't give you a clear answer. I'm just going to give you all the things that I think about in making that decision.
Thank you very much, Isioma. Thank you. So, Mr. Maruf Ajibade, I hope you've been able to get as much insight as you expected to get. So the next question is from Victory. Okay, let me leave it at Victory. What's your advice for a litigator who wants to transition into entertainment law? Can you recommend trainings for a beginner? How does a lawyer find opportunities in entertainment law?
That's a really good question. And I think joining this session, you're already on course. Luckily, with this requirement for continuous legal education, there are a plethora of entertainment law trainings that are going on. OOT Nominees is one organization I work with. And I think I did an introduction to entertainment law in November last year. And we're going to have a couple more trainings this year. I know OAL Academy is doing a training, which I am even joining, on disputes, ADR options for disputes in sports and entertainment. I would say invest in joining that. So I would say look at like the top entertainment lawyers, and when they're offering trainings, like join, because you could learn it. And if there are ones like these, or I know that I did a panel with NBA-SBL, and we're talking about AI. That was pretty much free. So just look out for these opportunities and learn. There's also so many resources online. There's so many courses internationally, that you can join virtually, that can really like give you upskill, and pay attention to the news. You can sign up to things like the Hollywood Reporter, Daily Music, because you get a lot of like information about what's going on internationally, that should, so that you are always ahead of what is even going on in the market here. And then how do you find opportunities? There are many conferences that happen in Nigeria that are targeted towards like different aspects of the creative economy. Endeavor to attend those things and meet people, introduce yourself. One thing about the entertainment law is that clients within that space are usually very young, very social media savvy. So when you've gotten the competencies, if you see that there's an issue that happens, comments, do a video. There are a lot of entertainment. I'm not even the best. I'm not very good with my social media. I don't do that. Luckily, I was able to build my career before the era of so much social media and whatever. And in fact, some of these new entertainment lawyers are giving me a run for my money. They put on the camera and they give good commentary about different things, and they're getting their clients. So you have to put yourself out there. You have to get into the space. You have to volunteer. A lot of what I do that helps me without being so loud on social media is volunteer work. Oh, they're calling people to come and make a comment on a new regulation or something. You're going to see me there. So you have to put yourself out there.
Thank you very much, Isioma. So to the next question. This one is from Ayodele Morocco Clark. With regards to fashion, how exactly are designs protected, especially in this era of fast fashion and perennial copying of styles and designs? How secure can fashion designers be?
This is an incredibly good question. And honestly, it's really a challenge. I think, first of all, when you have clients, so one thing people have to understand is that copyright protection pertains is automatic. Once you design something, because it's no longer an idea, you've put it in a fixed format. Let's say you've sketched it or whatever, it automatically has copyright protection. But the moment you mass produce that item, it loses that copyright protection. So this is something people need to understand. So one of the best ways you can do is to actually try and file design marks for your clients at the Patent and Design Registry to protect them. But the reality is that enforcement is also going to be important in terms of when you do file these design marks and people are found to be infringing, you have to enforce, because you have to deter people, and people have to know that if they encroach, there will be like there's a consequence. Why this keeps going on is because nobody can be bothered. Like if you look abroad, Zara, for example, was one of the first companies that started this height of infringement. When you had fashion weeks, they will replicate the entire thing and sell it for a fraction of the price. But you see, those fashion houses abroad tried at some point, won some cases, but eventually left it because they realized that they were not playing with the same market. Their customers will still buy their products because of the quality and the brand affiliation. So they didn't need to get into the mud with, the Zara and the rest. Now in Nigeria is a different scenario whereby, everybody is already struggling, right? These are not super developed spaces, so they really need to challenge these infringers. I've gotten these kinds of cases, and also you need to, as a lawyer, they need to approach this counterfeiting, because that's really what it is, the way the pharmaceuticals and the drinks companies do. You have to, do a whole sting action and find the root. For example, Turkey is a huge place where a lot of infringing copyright designs of fashion are coming from. And at this point, by now, one of these designers should have already taken an action in Turkey to mitigate that, and maybe potentially file defensive design registrations. So, for example, if I know that the hotspots for where they are going to counterfeit my products is Turkey and China, I make sure that I have my design marks registered. Like I advise my clients to register their design marks in Turkey and in China and in Nigeria, so that I can enforce in those markets and even stop it from coming in the first place. So there has to be more strategic thinking on the side of the fashion designers as to how they're going to approach it, because it really has gotten out of hand. So thank you so much. This was a really, really good question. I hope that the answers I gave will be helpful to you.
Thank you very much. Thank you, Isioma. So we'll take one more question. And the question is from Chukwu Yeri Onyebula. And it says, in a cross-border agreement, that the terms of payment is in dollar, but the contract is impacted by force majeure within the duration of the contract. How would you advise that the terms of payment be drafted as a result of fluctuation in exchange rates to ensure that your client still benefits?
I mean, my advice would be that you make sure that the dollar payment is tied to the prevailing rates at the time. Do you understand what I mean? So that although like it does not guarantee that it would, because if the rate falls, then your clients will get less. But that's the only way to do it. It's either you decide that it will be pegged to the rate at the time that the contract was entered into, or should be tied to whatever the prevailing rate, and you can maybe use that I think it's the OPEX window or something. You have to say where that prevailing rate is going to be determined, or you can say it's going to be the black market rate, and you can even tie it to what they call that platform where everyone likes to get their rate. So Abuki or something, you can actually write that into the contract. So it really depends on whether you see the currency falling and that will not be beneficial to your clients, or you want to maintain the rate at when it was high, or you are not sure, so you want to peg it to whatever the rate is at the time when the payment is to be made, and you can determine the forum that you are using to establish what the rate is. Hope that's helpful to you.
Thank you so much. Thank you. And thank you especially to our very esteemed participants who have stayed on the call. The number keeps growing. That tells that's a very clear indication of how much interest our participants have in this session. Unfortunately, we would have to wrap up at this point because of time. We generally try to keep our sessions short so that we can sustain attention. Thank you so much to our very esteemed speaker. I have learned a lot, and I'm sure our participants have really garnered a lot of knowledge within this very short time. Thank you for sharing your wealth of experience and knowledge with us. Fernandez is still here. Fernandez, I don't know if you'd like to say anything before we wrap up the session.
I mean, Ms. Idigbe, good afternoon. So we've not met in person, which is surprising because I've been to your firm several times. But of course, we've heard of your name. You're a legend in some places that we've heard. So, and of course, listening to you, and of course, we've seen some of your transactions, but listening to you, we're even more happy. And first of all, when you decided to agree to come, I was very excited. I was very happy. And then you have also done justice to it. So, on behalf of the entire SLP, we're really, 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 really very grateful for this. We're grateful for your time. It's not business. There are lots of things that you could be doing. You could be making money. So I'm grateful that you left money for us. And as you can see from the questions from the audience, it was very engaging. And we've been going on and on and on. So I'm really grateful to you. Thank you very much. Please, everybody, can you put your hands together for her? Virtually, let me see your hands.
Thank you so much, Mr. Obiene. Thank you so very much. I'm appreciative of the opportunity. Thank you very much.
Thank you. And for our attendees and for the moderator, you have done fantastically well. I heard your name before, actually, but I didn't know. Unlike Isioma, I've heard a lot about Isioma, but I hadn't heard as much about you. But I did a bit of research just after the nominations, and I was quite impressed too. I was wondering if you are from Bielsa. or Niger Delta or River
No,
State?
I'm not. Yeah,
Uh,
I'm from the Niger Delta. I'm from the southwest. Yes,
okay,
I'm from
okay, you
Delta.
follow. You follow.
Yes, yes.
So anyway, but thank you very much. Also, the same thing, you could have been making money. There are lots of transactions that you could have been doing. You've taken your time to do this. We're grateful. Thank you very much. And to our secretary, she's the one that is behind running around doing all the things. I'm grateful that she's able to join and keep everything on hold. Also to the administrator and the administrative team that have helped us put this together. I think that Rita should say something before we go because I want to thank her. She's done very much. She's the chairman of the subcommittee that put this together. So maybe we can just hear a word from her. But before I will hear from her, the audience, people have asked questions, people have been involved. You have done this, you have done that, you have been seeing your questions, you have been seeing the ones that tackle Damilola, we've seen the ones that. So I'm really grateful for the attendance and for those who the CLA point to be assigned as appropriate. I don't know if Rita is on the call at this time.
I'm not sure she is.
Okay, because she said she had mentioned before that she had some trouble joining. Any case, on behalf of Rita, or is there a member of the subcommittee? Is there a member of the leadership of the subcommittee present?
I don't think Mr. Onibokun is here or any other person from the Media and Entertainment Subcommittee.
Yes, I mean, you had sent a message that Rita was could not join for some technical problem. I don't know what that was, but I'm also grateful to them. And on behalf of the subcommittee, on behalf of everybody, I thank you very much, and I wish you a wonderful week. Remember, we have a session next week on the 22nd or the 26th. Then we have a regular session on the 29th, Thursday, and then every subsequent Thursday afterwards. The SLP conference is on the 7th of April and it's taking place in Lagos. So, whenever the information comes, do well to register. We'll have a session there. We'll also hopefully have a session at the NBA conference later this year. If there's any question that has not been answered, Damilola, please help put together so that we can ask them later. And that's all from me.
Thank you. Thank you, Fernandez. So I can see a few questions about CPD points. Yes, you provided you registered for the webinar. At the point of registration, your details would have been captured. So there's no need for you to type in any of your personal identifiers here. And there'll be no need for any additional link to be filled for your CPD points. Provided you registered for the webinar, we have your details, and that will be used to process your CPD certificate to get your CPD point allocation. Thank you once again for joining us. We hope to see you next week on 26th and again on 29th. Enjoy the rest of your evening. Bye.
Bye, thank you.
Thank you. Thank you so much. Bye-bye, everyone.